a.m., Associate Professor Dr. Ella Gorian from Faculty of Law, Vladivostok State University, Russia, Dr. Nur Sohaida Osman, Dr. Amarina Ahmad Fadli, Senior Lecturer of Faculty of Sharia and Law USIM, Dr. Farid Muhammad Hassan, Senior Lecturer of Faculty of Sharia and Law USIM, ILU committees, students, lecturers, and all the attendees on Zoom platform from Malaysia and Indonesia. Let's begin our session with the recitation of Ummul Kitab Al-Fatih. We are conducting our session in hybrid, whereby we are also live streaming in Zoom platform, and it is being recorded. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very wonderful evening I wish to all of you. Let me begin by extending a warm welcome to all the attendees of our intellectual talk today entitled AI Boom, the Future Has Come Earlier Than We Expected. I'm Shaza Sharif from Faculty of Sharia and Law USIM, and it is my pleasure to conduct this session on behalf of the International Law Unit USIM. Ladies and gentlemen, to begin this event, we are pleased to have Associate Professor Dr. Hasmi Rusli, Coordinator of International Law Unit USIM, to deliver the opening remarks. Please welcome.
Assalamualaikum. Selamat petang, good afternoon. How do I say welcome in Russian? I'm not too sure how to pronounce that. Dr. Ella taught me in the car just now, but I actually did not manage to grasp the word, how to say welcome in Russia. But I would like that. Добро пожаловать. Добро пожаловать. I would like to extend our warm welcome to our guests from Vladivostok State University of Economics and Service.
Yes.
Vladivostok State University.
Yes.
Okay, Dr. Ella and her sister Christina, who has flown thousands of miles from Russia, transit in Singapore for momentarily, and now in KL. We are very lucky to have them here today. We have I met Dr. Ella 4 years ago, back in 2019, when I visited Vladivostok as a plenary speaker in one of the conferences there. And we are lucky to have her back, to have them back here now after COVID restrictions have been eased. Dr. Ella has been here for a few days. When I drove her from KL just now, she told me that she enjoyed staying in Malaysia because of the clean air. Yeah, that was what she told me. Luckily, we have clean air today for her, and good food, as well as the warm hospitality of fellow Malaysians. So, as a Malaysian, I would like to welcome both of you, Dr. Ella, Christina, to Malaysia, and I hope this would not be your only visit to Malaysia. Hopefully, you will come here again in the future, in the near future. So today, the talk would be on AI, and as the coordinator of International Law Unit, I hope our audience, our online audience from Malaysia and Indonesia, and also audience here physically at the main meeting room would take this opportunity to ask as many questions to our guests today, Dr. Ella and also Dr. Salawati from UKM. Dr. Salawati, welcome again to the FSU. This is like the millionth time you have visited here. So I don't have to introduce you because you are now well known, right? Okay, so anyway, thanks again to both of our guests, Dr. Ella and Dr. Salawati, for being here. I hope you have a wonderful time learning about AI today. So I'm passing the floor back to Shaza. Thank you very much. Spasiba.
Thank you, Associate Professor Dr. Hasmi, for those wonderful remarks. Now, today we bring to you Associate Professor Dr. Salawati Basir from Faculty of Law, National University of Malaysia, UKM, and Associate Professor Dr. Ellen Dorian from Faculty of Law, Vladivostok State University, Russia, as our honorable speakers for today.
Yes.
Now, and for today's talk, we have Associate Professor Dr. Shamira Abu Chukur from Faculty of Law and Sharia USIM, who specializes in cyber law, child law, and legal education, comparative law, Sharia and civil as our moderator. Now, ladies and gentlemen, without further ado, I shall pass this session to our graceful moderator, Associate Professor Dr. Shakira, to moderate our talk today on AI boom. The future has come earlier than we expected. Please welcome.
Thank you very much, Ms. Shazan Osharif. Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon. Alhamdulillah, it is a great pleasure for me to moderate this session. First and foremost, I'd like to congratulate also the Director for International Law Unit, Associate Professor Dr. Muhammad Hazmi, and the coordinator for this program, that is Dr. Nuzhaida Osman, Dr. Amalina, Dr. Farid, and those who are physically here. Alhamdulillah, we are here to share what is artificial intelligence, the future is now. And on behalf of the International Law Unit and Faculty of Sharia and Law, we would like to welcome to our two lovely ladies here, Dr. Associate Professor Dr. Ella Korean from Vladivostok State University. So we might listen to Dr. Ella first, and then today I have the privilege to announce also our newly Professor Dr. Salawati. Officially he's a professor today. I just googled and it appeared professor. So I think I shall also congratulate to Professor Dr. Salawati, and to be honest, there are not many professors in law in Malaysia. So Alhamdulillah, and I'm happy because it's a woman. So Alhamdulillah. So without further delay, as you know that there are many progress and in terms of artificial intelligence. And before COVID-19, I've been reading this book by Richard Susskind. And I still remember in 2018, in an international conference in Singapore, we've been talking about whether there's a possibility to replace our lawyers with our corporate lawyers with robot. That was the debate. At one time in Singapore, we were talking about robot lawyers and so on. So as a brief introduction already been done by Dr. Hazmi just now. So the presenter today will be sharing about half an hour or 40 minutes. Our catchword might be, it sounds very serious, artificial intelligence, but we try to make it interesting, hopefully, and we might benefit each other. So without further delay, we would like to invite our lovely lady today, Dr. Ella Korean from Vladivostok State University. So I hope I pronounced it correctly.
You pronounce it very correctly. Thank you so much for a warm welcome. It's a great pleasure to visit your beautiful country, your beautiful state, your beautiful city, and beautiful life. So cozy, green, and peaceful. So I wish you all the peace and prosperity. As you have heard, the topic of our talk here is an AI boom, artificial intelligence boom. The future has come earlier than we expected, and the small spoiler, not the spoiler, but the synopsis of my these 30 minutes, I hope so, talk is the widespread use of artificial intelligence in all spheres affects data protection, cybersecurity, crypto, and blockchain. The government's attempts to regulate the artificial intelligence use address the ethic issues so far, whereas it's a high time for legal regulation. And during my talk, I'm planning to cover four aspects. from AI race to AI regulation race, crypto assets that Schürrlinger stat. The third issue is on deployment of artificial intelligence in finance and banking. I'll try to compare both Russian and Singaporean approaches. And the last issue I'm planning to cover is the AI regulation. It's a high time to proceed. And the spoiler is China is ahead. So, speaking of the AI race to AI regulation race, as we all know, the pandemic era of mankind history has demonstrated the flaws of both international political and legal systems. The race of high-tech giants and the nations they represent marked the official milestone of technological confrontation between opponents in the international political arena. The technological global race and the risks associated with it determine the foreign and domestic policies. Governments use all available instruments in their relations to rocket their chances and to marginalize their rivals. Their arsenal includes the variety of political, economic, and media levers, as well as the certain legal ones. Both formal rules of international organizations and international documents are a great opportunity to achieve the desirable. And as the example, I'd like to tell you this small story about the Russian anti-COVID vaccine Sputnik, which hasn't been registered due to the dubious formalities, and it demonstrated the dependence of the international bureaucracy on the political agenda. But this ban to register failed to prevent the international market launch of this Russian vaccine. Therefore, many nations have procured it for the national vaccination campaigns. And infringement of the finality during the development of a vaccine, which Russia was reproached for, didn't prevent from overlooking such cases with Western developers like Pfizer. As a result, despite the proven high efficiency of the Russian vaccine, it's not still approved by the WHO, and the Western big pharma blatantly admits the infringements committed during the development of their pharmaceutical products. So we can see that there are some political bureaucratical odds that prevent nations from being the leaders in the race, in the technological innovation race. As you can see, the artificial intelligence race emerges a race to the artificial intelligence regulation, and we can see the protectionist policy of each state given. Governments identify the important vulnerable areas and impose the relevant rules, which increases legal certainty and promotes the state in the race. A variety of data, including personal data, is the source of the AI technology's development. Therefore, government establishes a strict legal regime for information and for data. Such rigidity is subject to the internal logic of protectionism. The other example I'd like to provide is that China, Russia, and India are currently being accused by Western tech giants of severe restrictions imposed by national data protection laws. And there was a special term such as data nationalism. This term has been used, and at the same time, the technological giants are subject to the equally strict rules imposed by the United States, and these rules help the US government to control the technologies being deployed. As for the pros and contras, both the Western and the Chinese technological companies act for the benefit of their governments. They collect and provide the required information, serving as the instruments for the national policy implementation. And I'd like to provide two more examples. As you remember, last year there was a meeting, very important, politically important meeting of the Chinese Communist Party establishment, and the Tesla electric cars, which are quite popular in China, these cars were banned in the location where this meeting was held. And as the Chinese government says, and the Tesla developers confirm, Tesla electric cars are equipped with the AI systems that collect the information about environment 24/7 and transferring this data to American developers. The next example is the G20 summit, which was in ASEAN, in Eastern Southern Asia, and China emphasized its international leadership during this summit by monopolizing the summit support car park with electric cars of its own brand. So we can see this race of technologies and the attempts of certain nations to become a leader, to gain the leadership within this race. Therefore, AI technologies are of great importance for our mankind, for our civilization, for our international cooperation and political systems. The second issue I'd like to highlight is about, this issue is about crypto assets, cryptocurrency, Bitcoin, and so on. And I call this the Schrödinger's cat. As you know, this experiment with the Schrödinger's cat, is this cat dead or alive? We don't know, as well as the cryptocurrencies. What's the cryptocurrencies? There are three types of crypto assets. The first type is an asset reference tokens, including utility and investment tokens, cryptocurrencies. They also call decentralized payment tokens. The second type is the digital currencies of central banks, and the third one is the other crypto assets with controversial nature. Consequently, crypto assets do not and cannot have common rules of circulation. A crypto asset is just a generalizing category for different digital objects. Despite the fact that digital currencies are not a new term anymore, existing legislation hardly describes and fully regulates digital currencies such as Bitcoin and Ethereum. And legislators have made attempts to determine the legal nature of Bitcoin and Ethereum. For example, in Italy, Singapore, and Mexico, cryptocurrency is considered as a digital representation of value, which is used as a means of exchange for the purchase of goods and services. Implementation of this approach helps to establish a framework for cryptocurrency transactions based on the legal rules for foreign currencies, and it urges international cooperation on the issue. Of course, decentralized cryptocurrencies could play a role in measuring the value of transactions, but they are not legal tender, and therefore they do not have the function of money. And additionally, the absence of an issuer doesn't even allow considering cryptocurrencies as a monetary surrogate. And we all know about the high volatility of Bitcoin and Ethereum, and therefore these cryptocurrencies are being rarely used as payment instruments in routine activities. Individuals purchase these cryptocurrencies mainly for the purpose of speculation and resale when the exchange rate will increase. However, this feature doesn't exclude the possibility of trading cryptocurrency for goods and services. Decentralized cryptocurrencies store value and could be used for settlements among groups of individuals. Simultaneously, they have the features of speculative assets with the price backed only by the trust of investors, but they are not securities or bonds. And common ground is that payment tokens are negotiable if they contain an unconditional promise or order to pay a sum of money, or to confer on their holders a claim over the issuers or a redemption right on the reserved assets backing the value of the payment tokens. Bitcoin and Ethereum are created on the basis of cryptography and do not generate obligations for the person to whom they are issued. Furthermore, an obliged person is unknown and cannot be identified. So, at the meantime, cryptocurrency cannot be classified as securities as well. But there are some positions of courts in different jurisdictions. For example, the Court of Justice of the European Union states that Bitcoin is neither a security conferring on the property right nor a security of a comparable nature. Bitcoin, Ethereum, etc. may not be treated as money or as securities, but they store value for their users, which makes them similar to goods. The High Court of Justice in UK has stated two theses. The first one, there are not any barriers to classifying cryptocurrencies as property. And the second one, Bitcoin meets the criteria of property as it is definable, identifiable by third parties, capable of their nature of assumption by third parties, and having some degree of permanence. And the Singaporean International Commercial Court stated that cryptocurrencies are not legal tender in the sense of being a regulated currency issued by a government, but do have the fundamental characteristic of intangible property as being an identifiable thing of a value. And the American court, the United States District Court for the Eastern District of New York, finally stated that cryptocurrencies are more concrete and can be considered as goods since they fall well within the common definition of commodity as all other goods and articles in which contracts for future delivery are presently or in the future dealt in. So recognizing cryptocurrencies and Bitcoin as property raises the question of applicable law because it exists only in digital form and is based on distributed ledger technologies. This issue is especially topical in connection with the cross-border activities of cryptocurrency exchanges. And there are another issue emerges. The lack of information about the nature of cryptocurrencies intensifies the risks connected with price manipulation. Bitcoin is characterized by a high level of volatility as it is one of the most attractive assets for financial speculation. And price manipulations on crypto exchanges are based on the pump and dump scheme where market participants collude to coordinate the sale and purchase of a particular cryptocurrency and affect the Bitcoin exchange rate. And there is a vital necessity to introduce a clear system of monitoring scammer groups, decreasing the frequency of pump and dumps, which would be on behalf of regulators, investors, and recognized crypto exchanges. So that's about the protection of customers' rights as well. And I'd like to quote a very interesting thought, which been published, I guess, 13 years ago. Trading cryptocurrencies comes with a big risk. We pay real money for cryptocurrencies without even knowing if our investment will be fungible in the future. For example, if we will be able to trade it back for money or other goods. Therefore, there is another risk, the cyber attacks, and therefore crypto exchanges and custodians are among the popular targets for cyber attacks and hacking in order to steal bitcoins from clients' digital wallets. For example, there are two examples, like from 2017 to 2022, American customers brought at least 50 individual lawsuits and proposed class actions against intermediaries unable to protect clients' crypto assets from hackers and claimed losses ranging from as low kind of $4,500,000 to as high as $55 million. And problems with cybersecurity are common in the industry. The second example is that November 2022, when FTX and FTX US crypto exchanges reported that more than $400 million were drained from the wallets. And therefore, owners of Bitcoins and other cryptocurrencies need confidence in ensuring the security of their digital wallets, the ability of the crypto exchange to minimize cyber risks, and protection against cyber threats. And there is a very interesting approach of the crypto exchanges. Despite using different protection measures, crypto exchanges push their users into accepting custom agreements where they disclaim the platform's responsibility for any cyber risks. For example, the user acknowledges that he's aware of the risks associated with the transactions with digital currencies. The user agrees to assume all risks and that Binance is not liable for any risks or adverse results. Moreover, Binance's general risk warning informs that it is not possible for Binance to eliminate all security risks, and users are responsible for keeping their account password safe, and that customers may be responsible for all the transactions under their Binance account, whether they authorize them or not. And the crypto exchange highlights that transactions in digital assets may be irreversible, and losses due to fraudulent or unauthorized transactions may not be recoverable. Thus, crypto exchanges decline to guarantee the safety of customer assets as well as compensation in case of losses. In fact, digital platforms use their powers to make individuals responsible for the protection of data, which is being stored on the network infrastructure. And customers shall bear any losses because of the wrong tools and or methods of cybersecurity applied by the crypto exchanges. And this situation is in conjunction with the increasing number of cyber attacks makes investors extremely vulnerable. First conclusion is, if digital platforms do not ensure information security and data privacy, they must not shift responsibility to individuals, but instead should find a way to secure their clients' money, as well as their transactions issues. As transactions with cryptocurrencies have a transnational nature, national financial regulators are able to adjust these activities only if they would calculate and harmonize basic rules concerning the crypto exchanges, including data security and pivotal definition. Otherwise, the lack of regulation for intermediaries, including those that provide Bitcoin storage services, will fuel regulatory arbitrage and poorly affect consumer safety. Therefore, there is a great need, at least in model laws, need in guidelines or preferably international agreements, which respond to the issues concerning the protection of customers who trust their funds to crypto exchanges. As for the defining cryptocurrencies as the property or commodity, that's another vital question. It's another vital issue because it's necessary to define cryptocurrencies like Bitcoin as a property or commodity, which is being owned by a customer. This step will help to decide the bulk of issues, in particular the well-overdue difficulties connected with crypto exchange bankruptcy cases, when regulators raise the question of whether or not they should separate client Bitcoins from the assets of a custodian. In this case, consumers will be protected from the situation when all assets under the management of a crypto exchange are accounted as its funds and liquidated during insolvency. Understanding Bitcoin as a commodity gives investors an opportunity to claim their cryptocurrencies from a custodian and reduces the number of grantees losing their funds. So, national regulators are recommended to recognize Bitcoin as a commodity because it's not in the interest of a state's customers' well-being if it would be treated the same way as money. The third issue I'd like to address here is the deployment of AI in finance and banking, Russian and Singaporean approaches. Actually, there are two approaches to AI deployment: the regulatory approach and the self-regulatory approach. Russia is an example, as well as China, of the regulatory approach. Singapore is a very bright example of self-regulatory approach. In 2019, both Russia and Singapore, they made two very important documents. In Russia, there is a national strategy of development of AI 2030. In Singapore is a model AI governance framework. As for Russia, there is a definition of AI technologies in that document. Russian document clarifies the open list of processes where AI can be deployed. And Russian document contains the broading promising methods of AI. That is to enforce the possibility of including the other technologies that may appear in the future according to the Moore's law. Because we all know that according to the Moore's law, the development of AI technologies will rocket fuel, we will escalate in multiple progression. The specific regulation of AI deployment in finance and banking is still absent in Russia, as well as on liability in a tort. For example, which party is a tortfeasor, an operator or an author of tech? There is no legal certainty. The regulations of Bank of Russia, the financial regulator, cover such aspects as protection of information systems, risks management, and outsourcing. Also, there are some federal acts to be applied to different aspects of AI deployment, on copyright and patent protection, on personal data protection, on information and cybersecurity, and on critical information infrastructure. As for the Singapore, there is a model framework. The AI deployment regulation is also fragmented, covering provisions on copyright and patenting, on competition and cybersecurity, and online protection. Certain sectors of the economy, for example, finance and banking, are allowed to issue sector-specific regulations. So the Monetary Authority of Singapore, being a financial regulator, issued the principles to promote fairness, ethics, accountability, and transparency in the use of artificial intelligence and data analytics in Singapore's financial sector. These FIAT principles are being used by financial operators while deploying AI technologies and data analytics in financial products and services. FIAT principles rule the conduct of financial operators. Its violation is not a criminal offense and doesn't entail administrative sanctions. However, the degree of adherence to such guidelines affects the overall risk assessment for a financial operator. And in Russia, as well as in Singapore, the legal basis of AI deployment comprises numerous sector-oriented rules, but the special legal act on AI use is still missing. Only national financial regulators are responsible for AI deployment rulemaking, and the Singaporean one is a step ahead with its FIAT principles, promoting the unified approach and minimizing risks emerging from the use of AI. Nevertheless, both jurisdictions still delay the regulation of IP issues of AI deployment, such as the margin and the parties of liability in the tort. And the last issue I'd like to highlight is the AI regulation. It's a high time to proceed. China is ahead, it's a spoiler. As we all know, AI is the driving force behind the economic development of humanity, while the security of AI technologies is a key factor in the application. So far, governments and stakeholders from public and private sectors have been working on the development of ethical principles of AI, and some states have already identified fundamental ethical principles. There are different national approaches to regulation AI, including different regulation of the use of artificial intelligence for civilian and military purposes, and the delegation of authority for the development of ethical principles exclusively to the private sector. The unpredictability of AI decisions and the consequences of the application are the negative factors in using such technologies. Therefore, establishing clear and unambiguous legal rules on the use of AI is the responsibility of the state. Chinese regulators at the Cyberspace Administration of China on April 11th this year issued draft measures to govern generative AI services provision in China. So Chinese government is a way ahead of the all nations in the world because they already drafted all the core issues implying to the services that generate text, images, video, code, and other media. And its announcement follows the sensation caused by the US firm OpenAI's ChatGPT rollout, as well as a scramble by Chinese companies to offer similar products. And drafted, the measures for the management of generative artificial intelligence services would make companies providing generative AI service to the public responsible for the outputs of their systems. That's the kind of novella, because Chinese government imposes that companies which develop all these and provide these AI services, these companies are responsible for the outputs of their systems. And it would require the data used in training their algorithms meet such strict requirements. These draft rules are the latest brick in the regulatory structure that China is constructing around AI and related technologies. To make sense of this new draft, the most important reference point is the set of rules for so-called deep synthesis technologies that came into force 3 months ago. The document laid a solid initial foundation to regulate generative AI, including text-generating systems such as chatbots. The draft measures provide requirements that can cover a wide range of issues that are frequently debated in relation to the governance of generative AI globally, such as data protection, non-discrimination, bias, and the quality of training data. The draft measures also highlight issues arising from the use of generative AI that are of particular concern of the Chinese government, such as content moderation and completion of the security assessment for new technologies and algorithmic transparency. The draft thus reflects the Chinese government's objective to craft its own governance model for new technologies such as generative AI. These draft measures are a clear signal that the Chinese government is ready to crack down on the best data collection and processing practices that underpin generative AI models. At a time when European and Canadian data protection authorities are already investigating OpenAI's data practices and ChatGPT's potential violation of data protection regulations, Chinese authorities may be trying to preempt similar infringements by up-and-coming Chinese ChatGPT competitors. China already has a comprehensive data privacy law. The Personal Information Protection Law 2021 has limited Chinese companies' ability to cover up personal data by requiring prior notice and consent, as well as minimize data collection for specified purposes. The new draft rules feature reminders that existing laws like PIPL apply to generative AI systems too, but they also provide important additional clarifications regarding requirements that are specific to the generative AI context. In the last year, the potential of AI technologies has increased drastically, and their success in password cracking raises questions about the security of the cyberspace in a new aspect. Are the ethical requirements sufficient for regulation, or is it time to introduce legislative frameworks, rules, restrictions, probably restrictions on the use of such technologies? The answer is likely to be positive, as it is the state that acts as the guarantor of human rights and national security. time for discussion is practically over. The risks of hacking information systems in both the public and private sectors have reached critical levels. Therefore, the state must impose the legislative restrictions on the development and the use of AI technologies in cyberspace. Thank you for your attention.
Thank you very much, Dr. Ella. Ladies and gentlemen, Dr. Ella has highlighted 5 areas, and I might highlight only a few keywords that I personally also interested to explore further on data nationalism, on deployment of artificial intelligence, especially in finance, in banking sectors, okay, as well as what would be the major aspect actually of artificial intelligence and their implication to the international law. So it begs us to ask what would be the state responsibility in complying with the legislative, with the enforcement, okay, as what Dr. Ella mentioned, it is now, and it is too late, might be.
No, not too late.
Not too late.
It's a high time.
It is a high time,
Yeah.
okay, for all the authorities involved, okay, as well as we are in the law faculties, okay, to predict what would be the beginning of this fundamental transformation in law itself. So the floor would like to extend this discussion to Professor Dr. Salawati. So would like to welcome the lovely lady here in blue. Sorry. So Prof. Salawati will be speaking on AI and international law, current development, artificial intelligence boom, the future is now. So basically, as you can see, there are 5 aspects on automation, personhood, as well as weapon system control and standardization, okay, and how that artificial intelligence will have its implication for the international law. So as what Dr. Ella mentioned just now, banking sectors, cyber security, it begs us to look what would be the state responsibility in responding to this what we call very rapid challenges, okay, and how actually as a law lecturers, how do we cater our what we call teaching and learning, okay, where as we have witnessed during the lockdown COVID-19, we were forced to be online and we will struggle actually, okay, personally on how to use online we call lectures. So we're waiting for the slide to be on by Prof. Sarawati. So how can artificial intelligence actually improve human rights? And what actually the challenges of the artificial intelligence in legal education? And we have witnessed how research shows that hybrid work and remote communication are here to stay, as what we are doing at the moment. Okay, some of the audience, ladies and gentlemen, you are far away, but you're close to our heart in the discussion, okay, in this lovely evening, Friday evening. So the question is, what does this mean for the future of our legal education, legal fraternity, okay? And how is about the digitalization of the higher legal education, okay? Not only in Malaysia, but I believe that all law schools will be questioning on this matter. So, Prof, okay, so pass the floor to our relevant lady.
Okay, thank you very much, Associate Professor Dr. Shahira. I want to bring a different angle and the reality. Okay, my topic is AI and international law current development. Actually, many people talking about it, but we have to look very clearly, microscopically at international level, whether we are really ready with this or not. Okay, next slide. Okay, for the introduction, I just love to put that AI normally, very brief, they define on the basis of the factor of a thinking human being and in terms of rational behavior. They're always thinking that this AI can think and act like a human being, and the system that think and act rationally. This is something that international law have a dispute on this, because system is a system, human being is human being. We can see this in a many aspects of international law, but I will go one by one and see which field that really much into it, but what the field that they don't want to touch about the AI at all. Okay, next slide. Okay, if you can see that actually, this is not a new one. The artificial intelligence started in 1950s, and it started in 1960s, 70s until now. But this is the progress, because previously we are talking about learning, machine learning, and then after that, the deep learning. This is only the concept. And moreover, people associate it with the computers, with the system. And normally we go back to the I can say that people in the technologies industries, laws not so much being talked at that moment. Okay, next slide. Okay, I take one example. The pace of innovation in artificial intelligence. Normally the artificial intelligence are very vast in the security system, in the defense system. So I take this US Air Force, where US Air Force started in 1950, how they start with the dormant summer project, and there are so many, 1960, 1970, 1980, until 2020. You can see that after 2010 to 2020, the phase is a very, very much, because you can see they got the IBM Watson, Jeopardy, they got all this kind of project under AI. Meaning the military, the defense, the international humanitarian is actually catch up with this. That is the very vast one is international humanitarian, or normally for the defense they call it law of armed conflict. Okay, next slide. Okay, why I say it? Because in international relations, the competition to develop and control offensive and the defensive AI system actually led a new arm race. So this is that we can see. And I quote that President Vladimir Putin said in 2017, artificial intelligence is the future. Not only for Russia, but for all humankind. It comes with colossal opportunity, but also threats that are difficult to predict. Whoever becomes the leader in this field will become the ruler of the world. And this is true. After this, Russia never exported anything. China very much into their AI. After the project by Obama failed in 2010, they don't create something like this anymore. But the Congress of the US already said that AI is dangerous. So I believe US not so much into this AI because they really cannot catch up with what China and Russia do. Russia very close to it. China, if you know how to detect them, you know, but they're not going to tell you. Not at all. Okay, next slide. Okay. And if you can see also, this is what happened in international law when law is not clear or complete. In international law, the definition normally back to the country to define whether it's good or not, because you cannot force the country to sign and become part of a treaty. So the country will look whether it is good or not for us. Not all will sign for all. So what I can say that we will relate back to the law that we have. If you have a good law, then it's okay. But if you don't have, okay, one. Two, we're back to the constitutional law. This is always almost the time, okay, you don't find it, we'll go back to the constitutional law. So in AI, how do we go back to the constitutional law? Because constitutional law is normally is done when we want to have the independence and all the basic for the society, for all those, in future. But AI is not come at that time. Third, the litigation, the case law. You refer what the judges want to say in the judgment. Okay, the judge also will look back to what they have wrong. That's the law that you have. And go back to the constitution. And the fourth, like law by analogy and metaphor. And France, they love to use this. But not in the British common law like Malaysia or Singapore or Brunei. We don't do this. Fixed and principle. Okay, they cannot find the law. They find the constitution is very hard to follow. And how to determine and give the definition for the case, they common habits that we practice when it's come to the case. So that's how unclaused become more difficult as well. Because the military side already back to the AI. I taught the South China Sea area. They're already using this. But it's against the unclaused. And unclaused doesn't say anything. The country feel they will be affected by that conflict. So again, look at the principle of law, how to deal with it. And not the resources, as because you're facing the giant country like China, Russia, who not going to destroy the project. You don't know how far that they already done in their AI project. And first mover sets the rules. Who want to be the first movers? To be the example? No one. US are very anxious and quite worried, saying that AI is very dangerous to the country. Dangerous, that's all. Easy. Biden is easy, actually. Dangerous, that's all. But for Russia, no. You get it, you rule the world. So, and that's why, and you have to understand that this is something that, for me, in international law, is confused because not people look at the same way. But if you are in the international humanitarian side and defense side, you know what to do. That it will relate like UNCLOS or any other treaties. But if you are just from trade, for example, you are more going to what you said just now. They don't see this. So they are more on the basis of the calculation and the profit and all that. So next slide. And this is the 5 phase of AI regulation, and not the law, it's just a regulation. Normally what the scholars say that, okay, realization, you realize what's the problem. What's the problem? And then again, when you realize it, and you don't have the law, you have to go back to the ethic and principle framework. That's how you regulate that. So then, because the very important is the ethics. Ethics bring integrity. And in international law, not many people talking about the ethics and integrity of international law. And I can find out that not many people write on it. Because they are very believe integrity and the principle is only back to the normal national or domestic law. It's wrong. The realization and the ethics and principle framework actually is a practice. The regulation, when you don't have the basis on international, you go back to the principle, and then you also ethics and principle into practice. What is the practice? That's why the customary international is very important nowadays. What's the point time? We already lapse of time on that. It's just like not important. You want to go for the written law. It's wrong. There is certain law nowadays in international law. You need back to the customary international law, especially against UNCLOS and also trade. And also invite, I can say that on the security issue. What is the practice regarding the boundaries, delimitation, and also a jurisdiction of a certain countries, especially when it's come to their the rules and law that practice. Like ASEAN, Malaysia are not using the same law like Indonesia, and Thailand, no. What is Singapore and Malaysia almost the same, but they are different countries, but we have a basic from British. So at least we understand each other, but the others we don't know. That's a problem for us actually. So this is the when you want to have the AI, then you see that whether the country or the region is ready for it. And also, and you see the legislation. I make it right. Because the legislation, you need organization, or you need to have this. And in the competition, you need to see the competition, because why it's happening. And come back to the business side when you have the competition. And again, like you say, like Dr. Ella said, the design, use and data, you need to have that, because this is where the AI stands for it. And sorry to say, developing countries don't understand this. I bet if Malaysia understand this. I don't think so. That's why we got day by day, we're gonna have a problem, because world are more loose in terms of the attraction is like people can go here and then people are moving, no boundaries. But the law still stick like that. And there is a problem. That's why international crime, like UNODC was telling, is getting more serious. Trafficking people, trafficking drugs, piracy, they're using AI. So you see, this is a problem that if the authority of that country don't follow, it's the right kind of work. So if you don't have the legislation, then what you want to take action? You can't do anything. And thus, you must have the international adoption or adaptation. How do you have the country to understand if the red part, the number 4, they don't understand? This is a problem. Even in Malaysia, you see that. We have international cases, but the judges don't understand, and they have to look at all the local ones to give the judgment in this international case, which is wrong. Unlike Indonesia, now they are practicing with their, I can say that judges are being sent to the other country, and also their Ministry of Foreign Affairs are working with the local, especially because they got many type of courts to work together and see how the international practice. So then, what is the best for Indonesia? So in Southeast Asia, only Indonesia who are really vast on this, and I believe they are preparing themselves. They are preparing themselves, but they don't tell it. But the movement is, they will have this. So they need to ensure that their judges, their regulators understand this first before they can enforce. This can be seen, with the new asset in the Indonesian defense. I can say like armed forces. Yeah. Next slide. Okay, there is a ramification for public international law, because there are significant ramifications when it comes to the effect of AI international law. Public international law is somewhat resistant to AI technology due to its nature and the characteristics, like I said just now. Because the way international law is based back to the country, like for example, human rights. Western cannot say their standard human rights is the best. Even Muslim country cannot say that they're the right, because people see it different. That's why in terms of international human rights issue, the court will always say that go back to the country, look the practice, look the culture. They're not going to say good or bad. Because if you say the Muslim is wrong and the Western is right, then the Muslims say no, we are believing in their religion. Playing religion with international law is a very dangerous thing. So everybody would not going to say that. That's why, to make everybody understand the UDHR, okay, go back, what is the standard that you practice in your country? It has to be like that. That's why for us, we're looking at the people, wow, that's very bad in Pakistan. Pakistan like this, but that is the tradition. You cannot say Pakistan, this is wrong, Malaysia is right. And Pakistan will say, no, that's not what we do. This like this. So like a Western country, it's okay to same-sex marriage. It's not going to happen in Malaysia. You try it, you know where you're going. So that's the thing. If I say that it's okay, I want to advocate people, it's a right, then you will see I'm disciplined. I don't know where I'm going after that. So this is the issue. That's why I said, this is where, because the characteristic of international law is like that. And then it's hard to apply machine learning to international law directly. For example, there are so many lecturers, international law lecturers in this room. Tell us which machine you want to lecture today when it's come to this AI, when it's come to international law. They're all treaty, they're all cases, they're all opinion juries and others. So this is a problem. This is a problem that we can see in the development. Okay, next slide. And also you can see that the first ramification that for international rights, they range from very subject until having different rights and obligations. And I say we got many international economic, international human rights, jurisdiction, sovereignty. So this is a different topic altogether, but very connected to each other. So that's it. And second, some treaty text being notoriously ambiguous to interpret. Okay, look at the Treaty of Montreal. You take one, you give up. Because there's Malaysia, we signed in 1965, 75, but never ratified. Because when you sign, it's okay. But ratification, do not understand them. Because we don't scientists, but we don't nuclear law. So that can look at, we sat down with the AG chamber and say, this is cannot be done, this is done. So this is the problem. And then the third one, customary international being hard in some cases to acetate. As I said to you, actually many people who international law, they are struggle to understand what is the customary international law. That is the big problem. And that's why you write something that you believe, and then after that, for those who are really in that field, read it very carefully and find out so wrong. Always look at it, but only not my style to bash people. I don't like. But I can understand the understanding of certain people and under international law is if you don't understand the cultural and you understand the customary international law, you actually don't understand it. You need to know because that is the first, and after that the written is okay. The written law is no problem. And number four, a large number of sources of jurisdiction that can orient decision in unpredictable way, coupled with relatively few international court decisions. CJ, different judges, different understanding. They come from around the world. They got 7 people on one session, different idea, dissenting, agree. See the Tribunal of Sea, the Tribunal of Trade, the Tribunal of the DSB, and so on. So this is each other when it comes to the AI. The forensics is different. The style is different. That's why the international court decision, I bet that even international judges understand it. That is my concern. And the fifth one is the language barriers. In the case of a domestic court deciding cases related to the application of international laws, there's again how far that the local judges understand international law. That's why when we say that we should have more international law subject with the student, many law schools say no need, not important. But you will see later, 10 years later, we will collapse because our children not learn international law enough, and when they become a judge, they're like, but it's okay, 10 years later, I will be retired, so I'm not going to do that. I'm just looking. But this is a problem, my concern. I raised the concern here about it. Okay, next slide. Don't worry, my slide is just about 2 or 3 and finish. Okay. Regulation on international level, saying that the international level doesn't do anything. The United Nations and all the special agencies under it, they will play a central role. And the OECD, especially all the developed countries in Europe, also putting large emphasis on AI development. However, you can see, UN, they have the UNICRI or Center for Artificial Intelligence and Robotics, which is based in Denmark. So they have that. And UNESCO different. UNESCO, they don't want to be physically AI, but in November 2021, they have the global agreement on the ethical aspect of AI in the education. They don't want people to use education to be more fundamentalist, more terrorist, no. So they put ethics, as I said, very basic in the regulation. Okay, next slide. Okay, we go for this regional. The regional in the world is only European Union. RoboLaw project is to promote innovation in the internal market and foster competitiveness with European values. European using AI for economic factors, not humanitarian factors. That's why they don't like refugees. Okay, so if you can see, this is the 5th area that covered under the European Union AI regulation. First is a health safety, consumer and environmental regulation. That's why if you want to export your product to Europe, their safety, I can see their safety regulation is very tight. And they can make a random check to the ship. And that happened to Malaysia in 2010, when they random checked into Malaysia, one of the ship regarding the marine product, and they found that the salmonella Salmonella's bacteria with one of it, and they said no marine product from Malaysia. We lost 5 billion within 3 months. 50,000 people almost lost a job, and it makes a wake-up call from the Ministry of Health and Ministry of Trade who went to Europe and discussed blah blah blah. They said, okay, one charge. If we found it again, no marine product. So far we managed until today is okay. And then if you get to liability, Europe are very much liability, especially product liability and liability in certain sectors, especially industries. They have a certain quality. They don't tolerate. That's why sometimes when Pakistan is always put so much textile on Europe, then Europe will say anti-dumping, anti-dumping. So turn it back. Yes, anti-dumping. That is a problem. And then also the intellectual property rights. Or in Europe, that you cannot just simply take someone else's work. In Malaysia, it's common. You paraphrase certain words, and you know that it's from someone lecturer, and you use it. If you want to check on a student, they will all die. Because you know that if that's why I don't like online. I love physical examination because if online the tendency to text or copy somebody else is very high, and we don't have that application that can send the student which part that they take. And also the privacy and data protection, that's a very much in Europe. That's why you feel very safe. In Malaysia, the bank people normally were selling the number to the insurance people with the one number 10 ringgit, and after that calling you and saying you want to buy. So where you got my phone number? And I got managed to know this because one of this agent came to the room. I said, where you get my number from? Who? And they said, oh, one bank, one bank, they're selling 10 ringgit per number. See, this is a problem. This is make the first world, the attitude, the thinking. And then also the capacity to engage in legal transaction. Europe very tight, very smart, and you don't simply send the money, they know what is going on. But Switzerland not going to tell you what, if you ask, normally corrupt leaders from third world country will put money in Switzerland because Switzerland is the business, Switzerland is the banking. So all those money laundering money is actually from the many leaders, especially from the third world country, Africa, Asian leader, they would dump in Switzerland bank, and we cannot trace it because there is the regulation just to have very much protection on that. Next slide. Okay, AI and legal development, as you can see that the theory of law and technological change sometimes is not work with international law. Because the technology change often sometimes move recurring dilemma. As I said to you, let me just say this now, sometimes certain aspect it will be more problematic rather than see whether there is way to solve the problem. And for the legal development, actually, international law needs for new laws. But how far that the scholars can amend many laws, and how far that we can make 100+ countries to sit down and have a consensus on that. Second, legal uncertainty. Of course, legal uncertainty because not all countries become a member, and not all countries see the same interest, and not all the countries believe it can work. And three is incorrect scope. Again, understanding of international law, not all people have. If you come from developed country, yes, you've got many scholars that can sit down together and have a consensus. But even like in Malaysia, you look at Malaysia, what is the consensus? We never get, you ask the scholars never get a platform. I never actually want to see how government can collect or can put all the international law lecturers from all university in Malaysia, sit down and listen to what we comment about what the issue of international law regarding Malaysia. Never happened. Never happened because they rely too much on AG chambers. Everything is in chambers. So I believe this is the word, the thinking. Unlike the country, other countries, Singapore or even Indonesia now, they are really looking for scholars and they're working with the government. So if you take scholars, that's the think tank for the government, you see different. Because we don't take money. We don't have anything. We're working for the country. If we do consulting, if they want to pay us, they pay us according in the rules. But if you're not going to get the one we got million, no, we're not going to do that because we do it for the country. Unfortunately, they don't see this. And then the legal obsolescence, I think that's also a problem because again, because the diversions of our countries, you can see at the General Assembly in United Nations, you can see that how if a certain country like to say no, and how powerful certain country influence others to sign the treaty. You can see that. The lobby is very much in there. Okay, next slide. And this is the last slide. The way forward, okay, how we can see from this, the way forward is the sectoral development is a current reality. We are still in development area. So, however, more modest application of AI may strengthen international law in areas such as monitoring, enforcement, or the development of better scientific models and more refined evidence based to guide diverse government initiative. This is the level where the international law involved when it comes to AI. I can say it's still intermediate and still very much not yet understand and perceived by many countries. That's why US love to have the capacity building in Asia and Africa for them to get more influence and for them to make sure that we understand this. But you have to understand that after COVID, the situation of many countries are different. We're facing more high price for the foods, for the things. So people are not much on AI. People are talking more economy. If you're talking Malaysia, we're talking more economy. So this is the reality of the international law regarding AI. So thank you very much.
Thank you very much, Prof. Dr. Salawati. So we are not end yet. Okay, ladies and gentlemen, okay, for those who are online actually, okay, you can actually write a question or you can ask directly by switching on your camera and asking questions. But before that, there are a few questions okay, already been sent to me. Okay, so I read the first question, ladies. Firstly, the first question okay, to the two speakers. Do you think autonomous ships would roam the seas in the near future? How would this impact security of coastal state? So that is the first question. The second question, Russia has recently created autonomous nuclear submarines, also related to submarines. As a Russian academic, okay, so this is to Ella, specifically, do you think this would endanger global security? Do you think law of the sea convention will be amended to accommodate this situation? And the third question at the moment, okay, Australia is now working with us, with US and UK, via AUKUS to create nuclear power submarines. Do you think this AUKUS will stir Russia to keep on producing autonomous weapons? So open to the two speakers.
Thank you for your questions. May I have the questions? Right, okay, thank you. As for I think that any autonomous equipment, any autonomous vehicle should be at least governed by the human, because I don't believe in full autonomy, and therefore, how would this impact security? I think that with the proper approach, when the human being is being controlling these autonomous, they must be quite safe. But it's this issue is quite relatable, because what's the amount of attention should be paid by a human to these autonomous systems? Because I don't know, is it worth to trust these autonomous vehicles? Because the full autonomy is quite, as for me, is dangerous. So it will impact security. So I think that additional measures to be imposed for the security reasons. The second questions, yes, or maybe we can share.
You can answer.
Okay. The second question is about the autonomous nuclear submarines created by Russia. Would this endanger the global security? I guess I think that it would endanger, because it's as I said before, it's quite dangerous especially when it's a nuclear stuff. So everything nuclear should be controlled, monitored, and secured by the my personal opinion. Do you think law of this connection should be amended to accommodate this situation? Actually, remembering for how long did it take to create this UNCLOS convention? Yes, in it amended by taking into account all these 200 more than 200 states. I guess there should be kind of customary laws. So, and it must be backed, enforced with the honest opinion. So maybe the Security Council of the UN should be involved in this situation, because it's really, really dangerous, especially, you know, the seas, they're it's I think it's really dangerous, so it should be. And the third, as for the outputs with still Russia to keep on producing autonomous weapons, you know, it depends, probably, but maybe yes, you know, I'm not ready to answer this question now. Thank you for your questions.
Thank you very much, Dr. Anna. So yes, it's part of the keyword that Prof shared just now, readiness. Are we ready or not? So Prof, what will you be your feedback on the 3 questions just now?
Okay. Actually, when you're talking about the development of the assets and the military ship and so on, I think we are a little bit backward on that. But for the countries like China and Russia, they already explored it. And please remember, there is an incident of the submarine of US in the South China Sea, and they accused China, and the Chinese said, "What the proof?" But I don't believe that is China's work. I don't believe it. China got 73 submarines with nuclear weapons. Not all their submarine nuclear power. This differences nuclear powers with nuclear weapon, 2 differences. But China got more than 60 with nuclear weapon. So of course, when you have the nuclear weapon, you got the nuclear power, your submarine. Within 1 week with not nuclear power, you can be 1 month or 2 months down there. So you can do many intelligence works. You can retrieve all the area and all those depths and the things. And I think that there is, of course, there is given impact of security. There is no way you're not given any problem. There is. The only thing, how much they're aware of the coastal state. How good is the coastal state have the satellite? How good is their navy? How good is the intelligence of the navy, of the armed force? They're all back to the country, the budget of the defense of the country every year. That's my perspective. And secondly, when you're talking about Russia created autonomous nuclear submarine, why focusing on Russia? Why don't you look at other country too? Japan also created the other submarine, but then US said you can't do that. The submarine that the Japanese create is more cute. It's look like a box. It's not like the normal. You know, Japanese has always come out with a very digital things. So their submarine like a box, not like a submarine. So you thought it's a toy. It's not. It's something that and cannot be read by the radar. So that's why US said no, because US still, I think still got the bad dream of Pearl Harbor. They said no. So they stop it, but they have one. They show it. How they can go deep and all that, go deeper, because they make it like that. And US said no. So I think they abide by the after the World War II, so they stop that. So they don't use it, they don't want the submarine. And then also talking about China working with US and UK by AUKUS to create nuclear power. Do you think this AUKUS will tell Russia to keep on producing autonomous weapons? Russia always doing this. Russia, whether you have AUKUS or not, Australia or not, I always say that people don't understand and read Russia carefully. Russia and China, they are, if you provoke them, they never want to show any statement. You have to understand, these 2 countries are brothers. China will always be around the world to conclude their BRI. Russia will come to help China when the situation is cannot be controlled by China. But Russia not come with the armada. Like US come with the France, with Belgium, with Germany, they bring all the friends from Europe and even Canada. I don't know what's the connection with Canada with South China Sea. But they brought. Because they don't want to face one by one. But they are struggling one by, they are facing every day Navy from Vietnam and Navy from Philippines. They are fighting like they're really a conflict. They don't care. Only when US come with UK, with HMS Elizabeth, if I'm not mistaken, and then Parramatta, USS and Australia Parramatta, these three big ships with more than 5,000 people with the three ships. Then China caught the brother. Russia, these people try to be very hard with us. At South China Sea, they come with three big ships. That's all nuclear power ship, and UK sending the biggest ship. So what Russia said, don't worry, I'm coming. So what they do, they will send three submarines, big ones, and it crossed Malaysia side of Malacca Strait, and we cannot do anything about it. We were got intelligence saying that, but Malaysia submarine is only Kota Kinabalu, cannot go far from that. That's all. So since that we don't have. So we cannot stop it because they have the nuclear weapons inside there. So Russia come with three submarine and then make all those things. And US knows that. And US knows that. And US see that they divide what they're supposed to do. So they divide in front of Malaysia water and also the Brunei, and then go to the Philippines. Because they know if they encroach that 9-9, the China one, Russia will not hesitate to start. And as I said to you, people underestimate China and Russia without knowing that their technology is actually more better for me. Where people say, no, Russia, they are poor, they cannot know. Don't do that. Because if you never went to their place and see by your own eyes, you can say there's like, this one, why no? I have an experience with China. Until today, I said no. China, if they say they want to have war in South China Sea, they will do it. They will do it. They have all. The only thing, if they have a war, it's not bring any benefit because they want to conclude their BRI. So they just prolong. That's why they will prolong. Don't worry, they will prolong. I think all of us die. They will prolong. Because China will not go for war, but if US want it, they will not execute. So this is the thing. So Russia always back up China, but only certain situations, scenario, they will come. So they don't care, occurs or what, they don't care. They can do better than that. So for me, personally, let Australia have it. The Australia occurs. Because then it will influence Southeast Asia country to have the submarine with nuclear power. Like Malaysia, we need that. Because our area is very big, so we need more submarine to be stationed down. So then we know better who come to our strait, who going to encroach our jurisdiction. That's all.
Thank you very much, Prof. It is interesting to know also how the country is going to balance between safety and economy. As what Prof mentioned and Dr. Ella mentioned just now is the issue of readiness, and that same question also occurs when I did explore on whether we need to protect our children on the internet a decade ago. So whether the international law is ready to implement. And Alhamdulillah, in Malaysia, we can see that they have curiosity since the case of Richard Hackle, a British who came to Malaysia, and then it triggers the importance of protecting our young generation or young children, particularly in Malaysia. So I believe the issue of legislation, the issue of ideas, design, use data, and also whether the local people actually understand what is actually happening in our country, like how we try to convince the government at one time that pedophile is on the internet, and we try to convince the government also that we need sexual offences against our children, and I believe that that is also what happened in Russia, and as what Prof mentioned giant countries. They are in advance, okay, as regard to what actually happened on the internet specifically, and what would be the way forward, okay, in a small country, okay, like Malaysia, okay, in preparing our legal scenario on artificial intelligence. So, ladies and gentlemen, okay, we welcome. We still have time, okay, for question and answer session. So, for those who are online, or perhaps those who are here in this room, okay, if you have any question, okay, please join the discussion. Since the sound might not be very good at the moment. Yes, Dr. Farid.
Hi, good evening. My name is Dr. Farid. I would like to ask both of the speakers one question relating to AI and international law particularly. So as rightly have been mentioned by Professor Salawati, that at the international level now we do have ethical principles which have been passed by UNESCO, but that ethical principles only deal with on how to teach our kids, our youngsters on using AI, but not to regulate AI on a general and on another areas of international law, particularly on commerce and also on criminal laws. And as we all know that we have a treaty on the prohibition of nuclear weapons, TPNW. But unfortunately, that those countries which have nuclear powers have never ratified or acceded to this treaty. If in the future that the international community intends to sit down together and to pass a treaty at the international level, do you think that those countries which have the AI with such technologies, for example, China, the US, Russia, and so on, would have also become parties to this proposed treaty, unlike that we and as we have seen in the treaty on the prohibition of nuclear weapons, that none of them have become parties to. So, what do you what's your take on this matter? Thank you.
Thank you very much, Dr. Farid.
Okay, thank you so much, Dr. Farid, for your question. And I'm not that optimistic as for the AI regulation, because the Russian approach to AI regulation is the following. Russians, they divide AI for civilian needs and for the military needs. So if this agreement, if this international document will be aimed target, the target of this, the scope of this document will cover the civilian needs, I think that Russia will join this agreement. But I guess any slightly hint that it might minimize the military side of the military forces, the military policy, I'm not sure that Russia will join this document as well. Maybe the other nuclear states as well. So I totally agree that there is a great need, but all this political, all this politics. So national interests and national concepts of the international order. Because there's the theory of state sovereignty. The state is sovereign body, so therefore state decides whether enter or not this agreement. So I'm quite pessimistic on the whole scope of this agreement. So for civilian needs, for economics, for maybe combating crimes, but even there are different approaches or different views on combating crimes, like the computer crimes, the cyber crimes. Russia hasn't joined yet and hasn't signed the Budapest Convention. So you see, that's a common issue to combat these cyber crimes. But Russia kind of withdrawing and waits for something, or maybe building its own system of combating these cyber crimes. So this is my answer, and hope I replied. Thank you.
Thank you very much, Dr. Ella. So pass to Prof.
Well, if you're talking about the nuclear issue, actually that is all agree is politics. Okay, actually we have the NPT, where we're talking about the Treaty on the Non-Proliferation of Nuclear Weapons, where very good, but not force people to become part of it, which is India and Pakistan are not a member. However, US go and help develop their nuclear program. And these two countries, not only nuclear energy, it's nuclear weapons. So people are questioning this. And one of the reasons why North Korea withdraw from this is because this attitude of US. You are very busy with asking other people what you're doing, Iran and all that. So you not go and ask them how many the nuclear plant, what else the nuclear weapon that Israel has. So this is the problem. So if you're talking about an NPT with me, NPT is a plastic. It's just like, okay, everybody, you have the nuclear people, keep it there, don't give to other people, okay? And you don't have, like Malaysia, don't ever ask, something like that. What is Pakistan and India? What makes you have both of them? You know, both of them are not in good sense, actually, their politics and so on. This is double standard. Since this double standard, North Korea withdraw themselves. But you treat Israel very well, you treat Israel country very well, so what? So for me, if you're talking about nuclear, there is not sincere in that. Is everybody, for example, US say, okay, we need to use the peaceful of nuclear, and all those nuclear weapons that we have, we will make it, we will try to make it like obsolete, or make it like we try to dump everywhere wherever it is. But looking back, it's 1950s weapon. Of course, it's out of date. If you want to let it go, so no problem. But the latest one, just take 203, where all the new technology being used on Afghanistan and Iraq. Simple. So for me, I'm not surprised. These people are just talking, but at the back of it, they were still backing the country like Israel, which is they don't allow any EIA to come and check their country and be backed up by US. Again, I want to say, if they want to tackle this problem, Security Council should have this, but no. And the lobby is very much at this assembly. So it's just like that. And they will and now, but don't look down that the Bangladesh are doing that very well. And bear in mind, South Africa is also the country that produces people. So and many people always think South Africa is a black country. It's not. All the industries are by whites, and more whites and many Jewish in that industry. So connection to what happened in New York is very much happening in South Africa. That's why people always say, oh, Africa, black people, poor, blah, blah. No, very wrong. And even certain countries like Tanzania, Kenya, and Ghana is also now trying to understand whether they can have the energy by the nuclear plant. Despite they also not give all the water to their people, they are talking about nuclear plant. Something, who give the idea? Who encourage them? Then you can see that. Again, I agree with you, this is all politics.
So thank you very much, Prof. We still have time. Okay, if there's any question, yes, please. 2 questions.
Okay, I have a question to Prof. Salawati. I'm not sure whether this is the same question as what has been proposed by Dr. Farid just now, but my question is, as far as your argument is concerned, you stated that our country, Malaysia, should have a nuclear power submarine, isn't it?
Yes.
Okay. Okay. So don't you think that it goes against the spirit of the zone of peace and neutrality, which is ZOFAN, and also the Southeast Asian nuclear weapon free zone?
No, you have to understand that if you want to use it for peaceful purposes, there should not be a problem, because if you have nuclear energy in your submarine, you can go deeper and you can stand down more. So for the prospect of security of your country, it's okay. Especially Malaysia, we have so many problems. Strait of Malacca, near Batu Putih, near Vietnam, with China. We actually the most dangerous country in Southeast Asia. And yet we only have one submarine and we'll be very peaceful with that. That's wrong. If you're talking that to me, I think we should have at the Kuantan one, Lumut one, Kuching one, and Sabah. 4 at least. You have to remember, we do not use nuclear weapon, nuclear energy, no problem.
Doctor, hello. My name is Farani, and my question is a movie-based question. We have watched a movie called The Terminator, whereby in the movie it was said that a cyborg assassin from the future, which relates with AI, I believe. So my question is that, do you think that based on the movie, it can happen that the world will be controlled by AI if there is no regulations that regulate the development of AI?
Thank you for your questions, but unexpected question. That's yes, yes. I guess it depends. It depends because there's always I guess that now AI technologies, AI vehicles, everything equipped with AI still depends on human force, on human support, such as getting energy from the coal, oil, wind, or the sea by the energy of the tides, and therefore I don't think that it's going to happen because there is but the AI is kind of creative stuff, so it can create, but there is something that a human being possesses, and maybe I don't know, something human. I don't think so. I don't think so. That it might control like in Matrix or something like that in that old movie, if you remember that movie, but I don't think so because there is someone who has to maintain, to deploy, to repair, to utilize. Maybe I'm too optimistic, but I don't think so. So that's my answer. Thank you.
Thank you, Dr.
Okay, thank you very much, Udera. Dr. you want to respond? Movie. It reminds me of, I don't know whether your generation, okay, You Got Mail, okay, that movie. I think quite romantic, right, Prof? You Got Mail, okay, and also Identity Theft, also a Hollywood movie. And it happened to be, I met my husband online. Okay, we get know each other online. We never met before. Okay, but when we want to get married, we met before. Yeah. So that is basically nothing to do with, but it might be in the future. But what is worrying us at the moment is the idea of making robot to get married. That's what happened in Japan. So that is coming back about the issue of ethics and the principles. Okay, and whether if it is not controlled, okay, whether it is going to be allowed by the law, okay, to get married, of course, might not be happen in Malaysia.
Become habits and become custom and be accepted, then we'll be okay. That is a problem. That's why in Malaysia, we have to ban or try, okay, international will say we don't have human rights, but actually, we have to look the effect of it. Okay, for example, like Malaysia say it's okay, you want to have boyfriend and it's okay. Or parents say it's alright, it's your right, as long as you're happy. Yeah, it's right, you're happy, but what is the impact on the family? When kids have to see father and mother, suddenly father. And but then the father one acting as a mother. And after that you have one lesbian parent, oh, this is the father, this is the mother. What what is it? That's why I'm not bring the religion here, but that's why the religion against it, all religion against that. Because it is human nature of being. But if you look at rights, our people in Singapore now already try to. What is the effect in Southeast Asia, Singapore tried to do? Because Thailand, despite their open like that, but they not allow it. But if now, I do believe Thailand will be okay, soon Vietnam will be okay, Indonesia and Malaysia will alone too. No. But sooner or later, if our young generation feel that is a liberalism, hey, I'm doing what I want to do, I don't care. I might put people in line. So that's why then you will see, and many of these people come into the politics. They become the representative. And they say, it's okay, that's all right, that's all right. Soon Malaysia also will accept it. That's the problem. That for me, that's why the standard of human rights need to bring back to the country. Don't you try to say this is the standard of human rights like you have style. No, never can we work with us.
So we have almost 5 minutes to go. Okay, so I believe that it is the time to close the session. So Alhamdulillah, we had actually a very interesting discussion today. And on behalf of the International Law Unit, we would like to thank the audience, the hybrid audience, ladies and gentlemen, who are far away. And again, International Law Unit would like to thank the two speakers today, that is Dr. Ella, all the way from Russia, Dr. Salawati, from State of Selangor, now in the state of Zealand, also far away. Okay, we have to go a different state because now it is not lockdown. Okay, Alhamdulillah. Okay. So again, on behalf of the committee, we'd like to thank all of you who joined us, and we hope that the International Law Unit will be organizing more discourses on the international law aspects. Okay, we can have it now hybrid, okay, face-to-face, okay, alhamdulillah. So again, it is timely to say, I think I don't like to say goodbye, okay, but inshallah we hope to meet in another session. Okay, Prof, and also Dr. Ila, perhaps, in Russia, perhaps. Okay. So again, thank you very much to the organizer, to the committee who are around here, Professor Nadia, Dr. Hasbi, Dr. Nozuaida, Dr. Farid, Dr. Amalina. So we close our session by reciting Surah Al-As and Tasbih Kafarah.
A massive thank you to our distinguished speakers. Now, as a token of appreciation, I would like to invite Associate Professor Dr. Kazmi, together with Dr. Nur Haida, to kindly present mementos to the great speakers. My apologies. Now, please come. With that, I invite Dr. Ella Gorian as well as Professor Nur to receive our small yet kind gestures from ILU using. Thank you very much. Now let's remain for a photo session together, as well as with our Zoom audiences. You may switch on your camera for the photography session.
The new version of
Mana